Imagine you're cruising down a beautiful scenic road, really enjoying the view, and suddenly, bam, you're just bombarded.
Yeah.
Flashing signs, maybe some ramshackle structures, even abandoned machinery just cluttering the landscape. It really detracts, doesn't it?
It absolutely does. Ruins the whole vibe.
Or maybe, you've thought about building something or putting a sign near a main road,
Right.
only to find out there are these hidden rules dictating what you can and can't do. Rules you never knew existed.
That happens a lot.
Well, today, we're diving deep into a piece of legislation that actually, despite being enacted way back in 1940, profoundly shapes the physical landscape around our public roads. It dictates what you can and cannot see from them.
And what's really fascinating here is how this single law, the Advertising on Roads and Ribbon Development Act, 1940, manages to cover everything. I mean, from a tiny farm sign right up to the layout of whole townships and, well, the kinds of structures you see along highways.
It's incredibly comprehensive.
It really is.
And that comprehensiveness is key, isn't it? For this deep dive, we're using a consolidated version of the Act itself, so it reflects, decades of updates and changes.
Right.
Our mission today is to try and explain this complex but really crucial act in a clear, engaging way. Whether you're just a curious citizen, maybe a property owner, or even a law student trying to get your head around land use near public infrastructure.
Definitely.
We'll look at its original purpose, the key rules, the legal background, what it means in practice, and why it still matters today.
And if we connect this to the history, the act was formally assented to on May 14th, 1940, and it came into operation just days later, May 20th.
Wow, quick turnaround.
Yes. And that timing is significant. It really reflects this historical need to get a grip on uncontrolled development, what they called ribbon development, which was just sprawling kind of haphazardly along public roads back then.
Like endless strip malls today, but maybe the 1940s version?
Sort of, yeah. Just uncontrolled building along the road frontage. Dangerous access, no real planning.
And the Act's long title, the official description, it really spells out that dual purpose, doesn't it?
Does.
It aims to regulate advertisements you can see from public roads, but only outside certain urban areas. And it controls things like dumping old machinery or rubbish, putting up structures, even managing access points to land near these roads.
Exactly. So it's about looks, visual aesthetics, but also about orderly, safe development, preventing roadsides from becoming, well, an eyesore or even a hazard.
Right.
It was enacted by the King's Most Excellent Majesty, the Senate, and the House of Assembly of the Union of South Africa. That's the formal bit. But importantly, Section 18 says the Crown is bound by this act.
Meaning the state, the government itself, has to follow these rules too.
Precisely. Which shows its comprehensive reach. And as you said, it's been updated many times. The last changes incorporated, I think, January 1997, shows it's still very relevant.
Okay, so we get the big picture, the why. But to really understand this act, we need to get the terminology right. The definitions it uses are critical.
Oh, absolutely vital, because the language is quite specific and sometimes surprising.
Like the word advertisement.
Exactly. An advertisement here isn't just, a billboard selling something. The Act defines it incredibly broadly. It's any visible representation of a word, name, letter, figure, or object, or any sign or symbol.
Okay.
Or, and this is interesting, any light which is not intended solely for illumination or as a warning against any danger.
Any light. So like decorative lighting could potentially count.
Potentially, yes. If its main purpose isn't just to light up the place or warn of danger, but to, draw attention or convey something visually. It raises that question, how broad is this in practice? It could cover a lot.
That's fascinating. Have there been weird cases? Like what's the most unusual advertisement caught by this?
Well, you see interpretations in practice. Sometimes it's things like a brightly painted roof that spells out a company name, maybe even flags or banners arranged to send a message. The key is that visible representation aspect beyond just function.
Okay. And what about the roads themselves? You said public road, but there are distinctions.
Yes. A public road is one declared by law, like a provincial road. But crucially, it specifically excludes national roads, like the N1 or N2. Those fall under the National Roads Act.
Ah, okay. Different rules for national highways.
Right. Then the Act uses a broader term, road, which is basically anything for vehicles, includes bridges, fords, even interestingly, a default strip of land 32 meters wide if no specific width is legally defined.
32 meters, that's quite wide.
It is. It extends the reach quite a bit. Then you have the really important category, building restriction roads.
Okay, what are those?
These are specific public roads designated by the administrator, who is now generally the premier of a province or maybe a designated council, specifically for the purposes of this Act's building rules.
Got it. And you also mentioned urban areas and townships. Why are they important?
Super important, because many parts of the Act, especially regarding ads and some building rules, don't apply within these defined zones. An urban area is basically land under a local council's jurisdiction, like a city or town.
Right.
A township is defined as a group of urban or lots, but where the land isn't mainly used for farming. So knowing if you're inside or outside an urban area or township is key to knowing which rules apply.
Okay, that clarifies a lot. So let's dive into the first pillar, controlling advertisements. What does this mean for, say, a business wanting to put up a sign?
Well, the general rule, Section 2.1, is pretty clear. You can't display any advertisement visible from a public road unless you have written permission from the controlling authority, usually the premier's office or delegated body.
So permission is the default requirement outside those urban zones.
That's the starting point, yes. It's the main control mechanism. It lets the authorities manage that visual landscape along the roads.
But surely there are exceptions, like for my own business, on my own building.
Sure. Yes, absolutely. There are common sense exceptions built in. You generally don't need permission for an ad on a building that just gives the name of the business there or its owner or just information about the services offered right there.
Okay, that makes sense.
Also, exempt are signs, off the actual road reserve indicating a farm name or that a road's private, or maybe a warning sign like beware of dogs. Even simple gate signs with property names or warnings are usually fine.
So basic identification warnings are okay?
Generally, yes. But for anything more prominent or purely promotional, you'd likely need that permission. And the controlling authority has a lot of leeway.
How so?
Well, Section 3 says they can grant or refuse permission. And if they grant it, they can impose conditions like size, materials, how long it can stay up, exactly how it's displayed, and they can even revoke the permission later.
Wow, okay. So they have significant control. What if someone just ignores the rules and puts up an ad without permission or breaks the conditions?
Then there are enforcement steps. Section 4 allows the authority to issue a written notice. You get 14 days to remove or fix the ad.
And if you don't?
If you don't comply, they can come and remove it themselves, and then they can recover the costs of removal from you. So there are definitely consequences.
Who actually gets that notice? Is it just the person who physically put the sign up?
Good question. Section 5 sets out presumptions to make sure someone is held responsible. It's quite broad.
How broad?
Well, anyone who erected it or even just renovated it or has the power to remove it is deemed to display it. Plus, the owner or the occupier of the land where the ad is, they're presumed to have caused it or allowed it, unless they can prove otherwise.
So it casts a wide net. Makes it hard to say it wasn't me.
Pretty much. It also includes the manufacturer or the business the ad relates to. The idea is to ensure accountability.
Are there situations where these ad rules just don't apply at all?
Yes, Section 6 lists some broader exceptions. Things like ads on vehicles, as long as the vehicle isn't primarily used for displaying the ad. Like a normal branded delivery truck is fine.
Okay.
Ads displayed inside urban areas, that's the big one we mentioned. Ads put up by the state or road authorities themselves. Certain official road signs, if they have consent. And also trade names on things like farm windmills or machinery, provided that machinery isn't mainly there just for advertising.
Right, so a brand name on a tractor is okay, but a tractor parked purely as a sign might not be.
Exactly. Context matters. And being inside or outside an urban area is often the deciding factor for many signs.
Okay, that covers advertisements pretty well. Now, what about this ribbon development concept? The uncontrolled building along roads. How does the Act tackle that?
Right. This is the second major part. It's crucial for safety and just orderly landscapes. The Act controls this in a few key ways. Firstly, Section 8 deals with essentially dumping. Outside an urban area, you can't deposit or just leave disused vehicles, old machinery, or general rubbish where it's visible from a public road, specifically within 200 meters of the road's center line, without written permission.
200 meters. That's quite a distance. So no impromptu junkyards by the roadside.
Basically, yes. And again, if you violate this, the authority can order you to remove it or remove it themselves and charge you. There's an exception for, like, genuine farming materials or soil from digging, but crucially, it can't be on the actual road reserve itself.
Keeps the rural roadsides looking tidy and less cluttered.
That's the idea. Then secondly, and this is probably the most significant one for developers, Section 9.1. This prohibits erecting any structure or making structural alterations within 95 meters of the center line of a building restriction road without written permission.
95 meters. That's nearly a rugby field length, isn't it? That's a huge setback.
It is substantial, and structure is broad, includes things attached to the land, even things built underground.
Wow. Are there exceptions to that rule? Seems very restrictive.
There are important ones, yes. It shows they thought about practicalities. You generally don't need permission under this section if you're just finishing a structure that was already started before the road was declared a building restriction road or before a cutoff date of June 1st, 1939.
Okay, grandfathering for existing projects.
Right. Also exceptions for structures built by the Rail Commuter Corporation, structures within urban areas or townships, again, that distinction matters, basic fences under 1.6 meters high, and genuine farming structures like a farmer's house or necessary waterworks.
So he tries to balance control with the needs of farming and existing settlements.
Exactly. But for new, non-exempt development close to these specific roads, permission is needed. And it gets even stricter near intersections.
So,
Section 9A1 kicks in. Within 500 meters of an intersection between two building restriction roads or one building restriction road and any other road, you can't build structures or make alterations without permission.
500 meters, that's a massive zone. Why so large?
Safety. Purely about maintaining clear sightlines at junctions where traffic is merging or turning. It prevents buildings or structures from blocking the view, which is critical for avoiding accidents.
Makes sense. And if someone builds without permission in these restricted zones...
Same principle as the ads and the rubbish, the controlling authority can enforce removal, Section 9.4, but there's more. If permission is granted for a structure in these zones, conditions can be attached. Section 9.3 allows conditions like an obligation to remove the structure later, perhaps if the road is widened. And crucially, these conditions can be formally noted on the title deed of the land.
On the title deed, so it becomes legally tied to the property itself.
Precisely. It binds not just the current owner, but anyone who buys the land later. It's a powerful tool for long-term land use control.
That has huge implications. Okay, what else does it control regarding development?
Access. Section 10.1 restricts creating new access points like gates, bridges, or stiles through fences or walls along a building restriction road, again, outside an urban area or township.
So you can't just punch a new driveway onto a main road wherever you feel like it?
Not without written authorization, no. Unless it was an existing access point from way back in 1939, or there's a specific farming exception if there's genuinely no other reasonable access and certain survey conditions are met.
Why control access so tightly?
Again, safety and traffic flow. Too many access points directly onto busy roads create conflict points, slow traffic, and increase accident risk. This aims to limit that.
Okay. One more major control.
Yes, townships. Section 11 puts restrictions on establishing or extending townships near main roads.
How does that work?
Essentially, a surveyor general can't approve the general plans or diagrams for a new township, or even for subdividing land into smaller lots if any part of that land falls within 95 meters of a building restriction road or a main road outside an urban area. Unless the controlling authority gives written approval. Similarly, the Registrar of Deeds can't register the transfer of undivided shares in land in that zone without approval. It's designed to prevent uncontrolled suburban sprawl right up against major routes.
So it forces planned development further back from the road, or requires specific approval.
Exactly. Ensures that growth near highways is considered and planned. And just like with structures, any conditions imposed when granting approval for a township can also be registered against the land's title deed.
Making them binding long-term.
Correct.
This controlling authority really does have a lot of power under this act. What if you, as a landowner or developer, disagree with their decision? If they refuse permission, for instance.
That's a fair question. There is an appeal mechanism. Section 13.1 allows you to appeal to the minister, which nowadays usually means the provincial premier or their designated representative.
For which decisions?
If the controlling authority refuses permission under those key sections, Section 9 for structures, 9A for intersections, 10 for access, or 11 for townships, also if they grant permission but with conditions you disagree with, or if they withdraw a previously granted authorization.
And what can the minister or premier do?
They have the discretion. They can dismiss the appeal or they can allow it. If they allow it, they can basically substitute their own decision for the controlling authority's decision, granting permission or modifying conditions as they see fit. It provides a level of review.
Okay, so there's an avenue for appeal. How are the more detailed rules set out, like application forms or fees?
That's covered by Section 14. The minister or premier can make regulations to fill in the details. These can prescribe the exact forms to use, any fees payable, specifications for advertisements, how legal notices should be served, and the detailed procedures for lodging those appeals we just talked about.
And can these regulations differ by area?
Yes, they can be specific to certain areas or even certain roads, allowing for a bit of tailoring to local conditions if needed.
What about penalties? If someone really digs their heels in and breaks these rules building without permission, dumping rubbish, ignoring a removal notice.
Section 15 lays out the offenses and penalties. Contravening those key sections 2 for ads, 8 for rubbish, 9 and 9A for structures, or failing to comply with a lawful direction, like a removal notice, is an offense.
And the penalty?
It can lead to a fine, which the Act states as not exceeding R200, or imprisonment for up to 6 months, or potentially both. Constructing an unauthorized access point under Section 10 also carries the same penalty.
R200 doesn't sound like much today. Is that still the effective penalty?
That's the amount written in the Act from that consolidation. In practice, fines are often updated through other legislation like Adjustment of Fines Acts, but the potential for imprisonment or facing repeated fines for ongoing violations still gives it teeth. It's not negligible.
Okay. And one last point on the legal framework. Does this act interfere with other laws, like mining rights?
Good point. Section 12 explicitly clarifies that. It states that this act does not take away any power or jurisdiction that exists under laws relating to mining. So mining activities have their own regulatory framework, and this act respects that boundary.
All right, so different legal systems can operate side by side.
Exactly.
So pulling it all together, what does this deep dive tell us? What's the big takeaway for someone listening?
Well, I think it shows that this act, despite its age, 1940, is far from being just some dusty old law on a shelf.
No, it seems incredibly relevant.
It's robust, and it continues to actively shape how our roadsides look and, importantly, how they function, especially outside of the main cities and towns.
It really acts as a powerful tool then.
Definitely. For maintaining road safety, think clear sight lines, controlled access points, and also for preserving the visual quality, the amenity of our landscapes in those less built-up areas.
It feels like a real testament to long-term planning, trying to prevent that chaotic, haphazard growth before it happens.
Precisely, the kind of growth that could make our roads not just ugly, but genuinely more dangerous or difficult to use for everyone, whether you're commuting daily or just driving through.
It really strikes quite a fascinating balance, doesn't it, between allowing land development and protecting the public interest in safe and, well, reasonably attractive roadsides.
It does. It shows foresight from decades ago that's still paying dividends today.
So maybe the next time you're driving down a highway, especially outside a city, take a moment. Notice the lack of clutter, perhaps. The way buildings are set back, the limited number of driveways directly onto the road.
Yeah, notice what's not there as much as what is.
Exactly. And consider how this act, from 1940, still very much alive and kicking, is playing a silent but pretty significant role in shaping that whole experience for you.